Hi, good morning. What a very exciting presentation I'm following, which is Dana Long, my supervising attorney. I know due process and special ed law is a very, very heavy topic, so I'm sure your eyes started to glaze over. Don't feel like that's something unique. Mine do too. So my name is Stephanie Slone, and I'm one of the complaint investigators, and I'm going to cover the due process ICHAMP review. Here's the due process team. So I don't know, we like to put faces with names. We talk to schools all the time, and we have a vision of who we're talking to, and it's usually wrong, and it's just so nice to put faces with names. So you all know Dana. Tracy Tetrick, she is the virtual learning specialist for due process, and many of you have probably talked to her or will be talking to her in the future, especially as that expands in the state. Casey Symes, IIEP. She's the resource for IIEP for the Office of Special Education. All of us three in the middle are all complaint investigators. That's our primary job. But like Kristen said, we all have different roles that we play here at the Office of Special Education. And so IIEP is Casey. And then I am, and I know that's my law school photo. I just graduated last year. And I do Medicaid now. So I will do a presentation on school-based Medicaid after this. And then Kim Payton, she's the glue that binds us all together. We love debating amongst one another when we talk about Article 7 revisions. We will argue over a comma for 2 hours. And Kim's eyes just roll. But she holds us all together and is really the glue of due process. A little bit about me. So I am a non-typical mom. I have 3 kids, 16, 17, 18. My 16-year-old was born with autism. He had a lot of other health issues. So I quit my job and stayed home and raised him. First Steps is where we started, and then developmental preschool at the age of 3. Then I just had to advocate for him with the IEP and learned I had a skill of advocacy and a passion for special education. So I didn't have an undergrad degree. In 2009, I went to Ivy Tech for 2 years, got my associate's degree, went to St. Mary's in Terre Haute, got my bachelor's degree, and then in 2013 started law school in Bloomington. I also got a minor in education law and policy from the School of Education. So I have a very unique perspective, that of mom and of a complaint investigator, but I also went to school with administrators, and I know that the challenges administrators face in fulfilling their obligations for special ed law. So when we have all of these discussions, we've got Dana, Tracy, Casey. They were all school teachers. Casey was a special ed teacher for IPS, Tracy a gen ed teacher, and Dana was a math teacher. So we have these robust discussions, and we have all of the different perspectives. We're not here to be the bad guy and to make this a bad thing. We're here to help you. You have 4 attorneys at the DOE that have that special expertise with special ed law, and we would much rather help you in the beginning than on the end when we're investigating you and finding violations. ICHAMP. I love this. I am a statistical nerd. I love stats. And ICHAMP is an electronic database. It is akin to electronic court filing systems. So it's an online system that's designed to self-service features to make it easier and faster for schools and parents and representatives, which are attorneys, to file for those due process things that Dana just talked about. You create a sign-in, there's some resources over here, complaints, hearings, mediations. So it's a portal that's used to file complaints, requests for mediations, and for due process hearings. It's also a way for you as the directors or special ed directors or school leaders to manage these files. It preserves everything electronically and it keeps it. So if you had a case 2 years ago, it still is there, and you can still have access to those documents. So this is what happens. Each of you can contact me, or you can just go onto that website and create your own user profile. You still need to contact us so we can make sure that you're connected with your school. But the problem that we have, especially with charter schools, Charter schools seem to have a lot of turnover with school leaders or special ed directors, and that's understandable because you are innovative and are trying different approaches to education, and we completely understand that. But what's very important, especially with our part of our job, is to make sure that we have accurate school leader information and accurate information on who is the director, per se, for special education in your school. When we get a complaint, a mediation, or a due process hearing, we have to send that to someone. We send it to your authorizers. They get copies, but we also send it to the school leader and then that person responsible for the special education. And in the past, what has happened is the school fails to update that master file record, and then it goes to the wrong address. We'll fax it to the wrong address, and we're talking about potential FERPA violations because that is protected information. So it is very important that when you do get a new administrator, school leader, or someone in charge of special education, that you make sure whoever is in charge of reporting for the state in your school updates that information immediately. So I told you I love statistics, and this database can give us that. And it is a really good window into seeing how compliant schools are and what they're struggling with. So then our office can help provide that technical assistance. So, and I'm not going to hit the wrong button this time. In October of 2016, we had over 1 million public school students in the state of Indiana. For you charter schools, you had almost 44,000. So you had a little over 4% of all the schools in the entire, or all the students in the entire state. So for special education students, those with IEPs, we had 173,000 of those. You charter schools had about 6,000 students. So 3.5% of your student population is students with disabilities. This is what Dana was talking about, complaints. And what I do, and the other two, Tracy and Casey, we have to do investigations on every single complaint. We had 124 of those filed in our fiscal year of 2017. And each one is very, it takes a lot of time and resources on not just our part, but also yours. And it's emotional for the parent. Of that, 13 were on charter schools. So now you can start to see that that statistic increases. So 10% of our complaints were involved with charter schools, but yet your student population is 3.5%. So those reports that we talk about, if you and the parent can't come to an agreement and withdraw that complaint, they go to what's called a report, a complaint investigator report. That's actually published and is available nationwide. It does have your school name on it. It doesn't have the student's name or anything identifiable, but it talks about what you school did and what you lacked if you were found to be in violation. In this case, 52 of those reports involved 5 charter schools, 10%. But out of 52, there were 19 that actually we found violations. 5 of those were charter schools. So charter schools, you account for over 1/4 of all violations of special ed law in the state. So what does that tell us? It tells us that we need to do a better job in helping you understand your responsibilities for these students. Anyone have any questions? So I'm going to walk through with you on those 5 reports. And we're not here to start, pointing fingers. Again, I don't understand Article 7 completely. And we debate about it with our colleagues. It is complex. It is tough. We totally get that, and we're here to help. So the issue is, did this charter school provide a free, appropriate public education to students who have been identified as students eligible for services under Article 7? And we've included the citation, but I dropped off the 511 IAC because that's just kind of overwhelming. It's Article 7. So the facts. This charter school enrolled a student with a disability, but they refused to let him come to school. Fact 2, the school enrolled another student with a disability. The student was there one day, and the school withdrew him. They said they couldn't serve his IEP. So the conclusion that was found was that the school violated. Students with disabilities are afforded additional protections under Article 7, Rule 44. Dana just went over that. Public schools cannot unilaterally withdraw a student from school. So Dana also talked about the corrective action. What did we order that school to do to learn to become into compliance and to make up for what that student suffered? Well, they had to attend charter school training, which is exactly where you're at, so you're already a step ahead. And they had to conduct what's called in-service training for all of their staffs and administrators. And that was on the FAPE requirement and withdrawing students. So imagine what burden that places on the school when they have to train every single staff member and administrator on the law. It's quite a burden, but very important. So number 2, this is what the issues and they were found with violations. Revising an IEP without convening that case conference. A school just went ahead and unilaterally changed the IEP and didn't include the parent and all of the members of the case conference. And I've included the citations, and you'll start to see that there is a pattern. It's this particular 7-42. That's something that you all might want to just read over. Article 7 is huge. It has a lot of information, but there's certain areas that charter schools seem to be struggling with, and that is a particular rule that struggles. They also failed to include the parent. They also failed to include the student, parent, and the general education teacher. So if the student is in a general education classroom, that teacher, there must be a teacher in that CCC. They failed to provide the related services that were in the IEP that were based on that student's needs. And they failed to provide adequate notice. These are things that Dana talked about earlier. So what did we do? Well, we ordered that the school make up for that lost educational opportunity. So they had to do compensatory services. Those can include making up with occupational therapy, speech. It can also include sitting down and having tutoring. And sometimes these can get into the hundreds of hours. And then they had to go through significant in-service trainings. All right, here's number 3. And these are all published online, but what's important is not to point out the schools that made these errors. They made these mistakes, and most likely a lot of you do too. This one is that they were failing to implement the IEP, 7-42. The IEP called for occupational therapy. They didn't provide it. And these accommodations. If an accommodation is written in that IEP, it isn't for you to decide when and where the student gets it. The student gets it. So what did we order? 240 minutes of compensatory occupational therapy. And then they had to create and distribute a memorandum explaining how to implement an IEP. We doing good? All right, this one is number 4, and the issues: failing to respond to the parent's request for a functional behavior assessment, something Dana had talked about earlier and something that we'll talk about later in this training. They failed to convene the case conference when the parent asked for it. So the parent asked for the case conference to convene, and the school ignored that. They changed the student's placement. You can't do any of these things without that CCC making that decision. And they failed to comply with the manifestation of disability procedures. That's a tough concept. It's hard for me to understand what schools need to do in those situations. So if you're experiencing this for the first time, call us. Let us help you walk through that process so you're doing it right the first time. And we're not harming the student's educational opportunity, and we're not causing, sorry about that, we're not having more problems in the school either. So we're there to help preemptively. So what did we do? Well, it can get expensive. We ordered that the school pay for an independent functional behavior assessment, to convene the case conference, to develop a behavior intervention plan, to develop school procedures, and that specifically was on parental requests for an evaluation and how to hold a case conference, and then compensatory instructional hours with the opportunity for the student to make up that missed work. They also had to develop additional procedures, the manifestation determination process and procedures. Again, those are things that we can help you preemptively do so you're not getting it on the back end. Okay, this is the last one. This one was failing to convene a case conference at a mutually convenient date, time, and place to ensure parental participation. Again, 7-42. You see that? That tells us that that one area of the law is where we seem to have the most difficulty. So we had the school develop school procedures. So if you don't already have these procedures developed for your school, this might be a good time to write that down and start thinking about that and developing those. And if you need help, we're here to help. All right, so more statistics. So we just talked about the year 2017. Well, this is the year 2018 now. Our year starts July 1st to the next year. So we are on complaints now for the fiscal year 2018. So far this year, we've had 25 filed. We have 11 that we're currently investigating. 2 of these involve charter schools. So we've already issued 6 reports. 1 of them was a charter school, and 1 is still currently in an investigation status. We've had 2 of these reports have found violations. 1 of them is a charter school. So we still have work to do, but we're only a fourth of the way into the year. So there's a really good opportunity for you to take this information back to your schools and learn what other schools like you have made mistakes in and bring yourself up to compliance before, and then we can change those figures. So next year when we're having our charter school training, those numbers can be down. So just real quick, for this year, I wanted to let you know, again, what do we see? 7-42. I can save you all an investigation if you really just focus on 742. Failing to convene a case conference at a mutually convenient date, time, and place. Failing to give the parent adequate notice. Adequate notice, unless it's not, as long as it's not for that first case conference, it can be a couple of days. There's no hard and fast rule on how many days, weeks you have to give notice. Sometimes 1 day is sufficient. It's just on the circumstances of that particular case. And then fail to consider the concerns of a parent. What's the point of a case conference committee meeting? One of the hallmarks of the Individuals with Disabilities Act is parent participation. So it is important to have that parent. And there isn't one voice that's stronger than the other. And it isn't, 5-1 and then the 5 rule. It is supposed to be a conversation, a robust conversation about what that student's needs are, focusing on that individual student and not the personalities at the table. There are plenty of resources out there too that can help with that. IEP, the Resource Center, they can help you with facilitated IEPs. So then that takes it away from being school against parent, and you have that facilitator that's really running the show of that case conference and making sure that you stay on track and you don't let those personalities, crash and conflict. So what did we order? Develop school procedures. And this one, implementation of the case conference process. And then in-service training, they have on meetings, developing an IEP, and documenting. What's the point? If you have an IEP that says that you do XYZ, if you don't document that you did XYZ, what happens is we are going to find you in violation because the documentation speaks to what you did. And that's just the rule of the game. So make sure that you're doing your documentation. And then they had to attend charter school training. So you're already a step ahead. So Dana talked about mediations. That's a really good opportunity. When we get a parent that calls in to us as the investigators at due process, they call us, we don't just say, okay, here's your options, complaints, mediations, due process. Instead, we listen to what they have to say. And we ask, do we have your permission to call the school and to see if we can talk to someone at the school and see what's going on? A lot of times, the parents are frustrated, they don't feel like they're being heard, but they're only talking to the teacher themselves. Or maybe it's the principal at the school that doesn't really understand the law, and that's very common. So we try to see what we can do to help, because at the end of the day, it's about that student. And it doesn't do the student any good to wait 40 days for an investigation report or to necessarily go through mediation or due process hearing if it's something that can be resolved with a simple telephone call. So a lot of times, and there might be some of you that have heard from us when we're doing that, not so we can keep the numbers down, but again, it's about the student. It's about making sure that you're in compliance with the law. And, at the end of the day, that's what we're here for. So again, I just put those statistics up there, but this is what right here, 59 mediations in fiscal year 2017. We had three charter schools that participated. So if you see, we have 5% of all mediations, and that aligns with more on the alignment of statistics. So charter schools are using mediations appropriately and for the amount of students that you have and you're serving. We had 2 that reached a full agreement. So bingo, everybody walks away. The school walks away without that complaint hanging over their head and all those violations. And the parent and the student walk away, and the student's able to get whatever it was that they needed. And the Department of Education pays for it. We have 1 that was a partial agreement. So some of the issues were resolved and some weren't. This is the biggie. This is what's akin to a court. If any of you have ever had to go in a Social Security hearing or a BMV hearing, it's all the same. Those are administrative agencies. Those are administrative courts. How many of you remember Ryan White? That was our office. So this is what it is. The hearing officer ordered the schools to open back up for him. Then they took it on to the courts. Because after this, the next stop is either federal or state court. So total, we had 74 hearings filed last year, of which 3 were charter schools. So again, we're aligning statistically. That's in line with the state average and your number of students that you're serving. So 2 of the parties at some point in that hearing process came to an agreement, and the judge dismissed it. But remember what Dana talked about. You're paying for that school. That's expensive. You're paying for that hearing officer, and you're paying for your attorney, and any kind of other associated costs. And a lot of times in those agreements, the parents, part of that agreement is you're paying for the attorney fees of the parent. It's not always the case, but we're talking thousands of dollars, thousands. One of them was dismissed because the hearing officer said that he didn't have jurisdiction. That was an older individual who filed, and there was just no Article 7 jurisdiction. So, anyone have any questions or feedback about this part of the presentation? All right. Well, you know where to find us. And I know I talked to quite a few of you, and it's just really nice to be here, and I appreciate you listening. And it's not all doom and gloom. You're out there doing a fantastic job, and we recognize that. And we want to send that message that we are here to help support you.